I think the other thing that's really important for me to remember is, you know, it's important for people who have been victimized by these horrendous crimes to know that the international community believes what happened to them was horrible enough to require the attention from the international community, that somebody will acknowledge that horrible things happened and will hold to account those who are responsible for them. That's a huge deal when you're trying to, if you think of an international community, which, you know, we have more or less, we all really do belong to it, whether we think we do or not. When atrocities happen, people are removed from that international community. You know, they are accepted from it in some ways. And so part of the responsibility afterwards through courts and other means is to weave that web of community. And I think that international tribunals and other domestic tribunals have a very important role to play in that. So I'll stop there.
No, Judith, I think that's absolutely right. At least that's been our experience in Congo. I mean, we, as sort of ABA ROLI, have been in Congo since 2008, working closely, obviously, with the judicial system there. And so far, I think it's been interesting to see what impact sort of the international courts have had domestically. Obviously, Congo is a state party to the ICC. It hasn't implemented the Rome Statute, although that's pending currently before the legislature. But I think at least what I've seen in some of our cases is that they're definitely following it. They definitely understand it. And I've even seen them apply some substantive principles. We had one trial most recently in Kalima, which is a small town in Maniema province, where, you know, it was an interesting situation because the person who had committed the rape of a 2-year-old girl was a military commander, and of course had escaped. He had been arrested, but he escaped from prison. And we actually ended up, or should I say our local staff attorneys, Congolese attorneys, actually ended up bringing the case against the person who facilitated the escape. In other words, the guard, the prison guard. And, you know, we thought, well, we're not quite sure how this is going to go. This is not exactly your typical straightforward case against the direct perpetrator. And what happened was, in that case, the judge actually sort of relied on the principles of secondary liability, to some extent command responsibility, and we were actually kind of shocked and surprised. I mean, we've done a lot of trainings, you know, sort of with justice sector actors, but I think to see it being applied, I think was very impressive to us. So I think that there's definitely room, I think, for there to be some kind of intersection between the two, and I think it certainly informs what happens in these cases. I mean, obviously Congo's civil law, but it's still, you can still see the impact of it.
Mm-hmm. Well, isn't that, just to add a footnote to Natacha, isn't that sort of what the whole ideal of the complementarity principle in the ICC is supposed to be? That if the ICC prosecutor goes and says, I want to begin an investigation of this particular situation, that the country, either where the alleged suspects are or where it was committed, can come in and say, no, we're going to do that. We'll do it ourselves. And actually, the Rome Statute is pretty specific. The prosecutor has to let them do it unless he can show the court that they're unwilling or unable to do it. And right now, there are, 5 cases in active, Susanna would know the figures better than I do, but something like 5 or 6 cases in active investigation, besides the ones that are in trial, and 7 or 8 in so-called preliminary investigation, while sometimes he works with or tries to work with the judicial systems to bring them up to snuff so that they can do that.
Yeah, no, I think that's right.
What about the judicial, I wouldn't mind getting some of your feedback, Judge Wald, especially in talking about the quality of the expertise, whether at the international level or breaking down back into the domestic level, whether it's the judiciary, the prosecution, or the defense bar.
Well, my experience, of course, on the ground is limited to the couple of years I was at the ICTY, although I've gone back and worked both a little bit with them and some with the ICC and a little bit in setting up the Cambodia tribunal. But I'll speak mostly from my experience. I think in the beginning, the judges, the caliber of the judges at the ICTY, it's fair to say, it's been written about by other people, was uneven. In the beginning, I think some countries thought, well, here's just another place we can put, this nice diplomat out to pasture, as it was, et cetera, and I think that the countries did not realize that this was going to be not only a somewhat, whole revolutionary movement, but also that it was designed to and did, in fact, apply real judicial processes, not some kind of, once over lightly kind of trial. There were going to be motions, jurisdiction, there were going to be laws of evidence, there were going to be problems of examining and cross-examining and impugning by cross-examination witnesses. And so not very often, but often enough, too often, the people they represented had not only been judges before, but they had never been in a courtroom before. I mean, so that it's either a defense lawyer or a prosecutor. On the other hand, there were just some splendid judges. I served with Judge Hunt, who headed up the criminal appeals court in Australia, and Judge May, who died during the Milosevic trial, who I served with in other cases, who really knew what they were doing. But you had this uneven quality, and having come from the D.C. Circuit, which we don't always agree and never did always agree, for heaven's sake, but I would not ever impugn the competence or the legal training or the fact that they knew what they were doing, even if I didn't always agree with what they did. But that was not always true over there. So I remember complaining once to a UN official, this is back in the beginning, of this decade, complaining, and he said, look, what can we do? He said, the countries nominate them, and he said, unless they walk in with two heads, we at the UN won't or can't do anything about it. And of course, what happened was a selection process was done according to kind of geographical trade-offs. The Caribbean basin could have one, but this one could have one, this one to have a turn, this one to have a turn. So that there was one I'm not speaking out of school now, there was one poor judge over there who was from China when I got there. He'd been there many years, he was in his 90s, he hardly could make it to the court, so that basically his legal assistant was doing, in effect, most of the work. And he wrote to China, the Chinese officials, begging them to let him come home, and they wouldn't. So he eventually died in The Hague. But, I mean, that, I think, has improved greatly I've been back visiting since I left. I think that countries have become aware of the fact this is serious business. People are going to pay attention. This is a law that's being developed, which may, as you point out, actually trickle down into their domestic jurisprudence. So my general impression, not having served on the court since the beginning of this decade, is that the judges have been selected much more so for their competence, for their excellence. But still, I know that the Coalition for the International Criminal Court has now set up a committee, which I remember, which is going to do just sort of an evaluation of the nominations, just for anybody, that wants to know about it, to compare them with the qualifications which are set up in the statute. The other thing that came out of all of this complaining of people like me and various other people is that in the ICC statute, in the Rome statute, they actually say that the trial and pretrial chambers have to have a dominance, I think, or whatever the word is, of people who have had experience in the criminal justice process. So I think that in itself is, up the quality considerably. So I think, maybe having been a judge myself, I'm prejudiced, but I think in the end it is the judges, the caliber of the judges and of their work, which will determine the long-term credence of the court. And that's going to be true when we get down to the specific discussion of Judith's subject to the Milosevic trial.
I can guarantee that when Judge Wald spoke in the courtroom, all the journalists put their pens down and listened.
Well, that's not good. It means
it was usually an explanation of an evidentiary point, or it was some clarification of what was being battled out in the courtroom, and clarifications and important rulings. So if I could ask you one follow-up question, did you have any observations about the quality of the defense bar at the ICTY, the Yugoslavs vis-a-vis the internationals? Because in the Krstić case, you had two Yugoslavs.
Yeah, we had two Yugoslav from Belgrade, and they were, I gotta say, they were both excellent. Now, two observations. One, the Yugoslav counsel had not had much experience with cross-examination. It simply was not a part of their normal process. And certainly in the beginning, you had a sense. But there were two. One was a very high reputation, I'd say middle-aged lawyer, who was the soul of integrity, which we really appreciated, because at that point, some things were going on that, I mean, for instance, lawyers would tell us that when they sent their, confidential stuff back to Belgrade, et cetera, to their office, it would get there, it would have been opened, et cetera. And there were various things that were going on that were not, but he was just the soul you could trust if he gave a promise, if he gave. And the younger one was clearly an up-and-coming international lawyer, because by the second month of a years-long trial, he could cross-examine. I mean, he picked it up. So that my experience in that case. Now, I then had another case, which had 5 prison officials from a Serbian prison camp, or the Jomarska prison camp, which was a notorious one, the one you saw those pictures of that looked like, the Holocaust or concentration camps revisited all over again. Now there were 5 defendants who were lower level people. Krstić had been right under Mladic, was a high level official. And they each had 2 counsel, a Yugoslav counsel or a
one had a Bosnian, I think, a Sarajevan woman.
Yeah, but she was an assistant,
Okay.
I think. And then they would have an international lawyer, a Canadian, we had
Right.
some, or an English or a French kind of thing. Those lawyers, I won't tar them all with the same brush, but some of them certainly, you had to watch it a little bit. They didn't always cite the record correctly. It turned out subsequently some were getting kickbacks from the clients. The client says, or the client's wife says, if you pick this particular counsel, he's got to pay us back a certain amount of money. That got cleaned up. I mean, that got discovered and cleaned up. But in general, I would say that the level of preparation, the level of expertise was much lower, certainly, than that of the international lawyers. And the prosecutors, I had a large number of American prosecutors who've been seconded over from the Civil Rights Division of the Justice Department and other places. So that was like old homework for me. I mean, they acted the same way they did when they appeared before us in the courts here. But only one last comment I'll make. There are a couple of differences in the rules of the ICTY, which combine common law adversarial processes and some aspects of the civil law system. So there were things like the prosecutors can appeal acquittals, as well as defendants can make statements uncross-examined and not under oath. Our American lawyers took to that stuff just great. They appealed every acquittal just as much as did the civil lawyers. So